Let's go over estate of Fields versus a commissioner of the IRS. Miss Fields inherited an oil business when her husband passed away. She gave her nephew a power of attorney over her. Her nephew formed a limited partnership and transferred $17 million of her assets into it. In exchange, she received a 99% limited partner interest in the limited partnership. The nephew, after she passed away, the nephew got an appraisal, limited partner interest held by Miss Fields' estate, and discounted it 15% for lack of control and 25% for lack of marketability. He was the executive of estate, filed the estate tax return. Taking the discounts, the IRS imposed a penalty, or actually, they included the full value of the estate, not the 99% interest. They included 100% interest without any discounts, and they imposed an accuracy related penalty. This is basically a 2036 case. He went to an accounting firm that does know how to prepare 706s. They included the discounted value. They said after they got an appraisal, I believe, or maybe they just valued it without the. We'll see when we get to the accuracy related penalty. Um, he sold some of the assets to pay for the estate tax. Right, so generally presume the IRS's determination is correct. Taxpayer bears the burden. So the value of the estate includes the fair market value of all property the decedent owned on the date of death that is otherwise included. Um, if they made an inter vivos transfer, but they retain certain strings, that's pulled back into their estate under 2036. For 2036 to apply, 2036A to be specific, the decedent must have made an inter vivos transfer, and they retained an interest or right in the property at death, and it wasn't for a bona fide sale for adequate consideration. Um, it can be, the strings can be express or implied under case law. Here, it's funny because the nephew was the general partner, and he had a power of attorney, and together those two items resulted in the court saying that the decedent retained the right to income from the transferred property uh, because the general partner interest was managed by the decedent's attorney. In fact, I don't think that's a good holding, but that's what they held here. Did not actually, even though she didn't actually receive any income distributions during her lifetime, they said just that the existence of that relationship was enough. Another factor that resulted in inclusion was the fact that almost all of her assets were transferred into the limited partnership, with only 2 million outside of the partnership. Um, so she really depleted what was left in her own name to put everything into the partnership, basically, which they said resulted in an implicit agreement that they'd have to make distributions from the partnerships to pay her debts, one of them being the estate tax. And the IRS imposed the accuracy related penalty of 20% for negligence, or 6662. They argue that they relied on a tax professional in order to get out of the penalty through reliance on a tax professional. The advisor has to be competent um, with sufficient expertise, that they must have the necessary info, and the estate actually relied in good faith on their judgment. I guess here the facts show that that wasn't the case. So I'll always go to, probably one of the big eight, or a firm that specializes in valuations of closely held family entities if you're going to include a discount on a 706.